on that right away. So next slide here. All right, this is just our law firm, Senti Cedarburg. We're a leading national cannabis law firm. And for purposes of this call, I think it's important that we know we've got an office in New York and an office in New Jersey, in addition to California, Colorado, Florida, and Texas. We're the leading law firm when it comes to winning cannabis licenses. We've won licenses in 23 states, including one of the 5 original New York licenses. So without further ado, here's the team for today. And myself, I'm a partner and chair of the corporate group based here in Boston, but also admitted in New York. I'll be in New York pretty frequently. Excuse any mistakes I make today. I got my Johnson & Johnson vaccine yesterday, so I'm not operating at full capacity right now, but I'll try my best. Then we got Michelle Bodian, Senior Associate from our Hemp and Cannabinoids group. I'll let her say hi.
Hello.
Jennifer Cabrera from Licensing and Regulatory Counsel based in New Jersey.
Hello.
Elliot Choi, Counsel in the Corporate Group based in New York.
Hey everyone, and hey to my fellow Long Islanders out there.
Brandon Kurtzman, partner in the Licensing and Regulatory Department based in Boston, but will also be helping out frequently with New York matters. So just to kind of set the stage here about what we're gonna sort of walk through what I would consider to be the 12 kind of considerations that I suggest people think about when they're looking at expansion to a new state, when they're trying to understand a new bill. But before we do that, want to talk about the big caveat here, which is that all we're talking about right now is the bill itself. We don't have regulations yet. The website's up, but the devil's in the details with these kind of things. So we can't really give definitive answers or definitive advice on a lot of these questions until we actually get the final regulation. So this is just setting the stage. It's just the statute. Obviously, it's controlling and it's very important, but a lot of the details that you'll want to know are going to be in the regulations. So here's what we're going to talk about, sort of what I view as the 12 key considerations when expanding into a new market. One, understanding the legislation and statute itself. Elliot will explain that. Then he'll go on to talk about the different license types in New York, as well as the vertical integration prohibitions in New York. Then Jen will talk about the regulators and then the rulemaking timeline. Then Brandon will talk about local licensing and equity considerations. Then I'll talk about ownership restrictions, taxation, and transaction considerations. Michelle will talk about hemp and cannabinoids and advertising and marketing. And then we'll bring in the whole group to talk about what can be done in advance of licensing. Can you buy a head start, et cetera. And then we'll open up for questions at the end. So if you've got any questions, just type them into the chat. We'll try and answer them as we go along here, but we're going to try and save time for the end. So, given the shortness of time here, without further ado, here's Elliot on understanding the legislation and statute.
All right, thanks, Charlie. And Elliot here again. Hi, everyone. Corporate Counsel in Vicente's New York office. So finally, New York legalized. As we all know, last Wednesday, Governor Cuomo signed the MRTA, making New York the 16th legal state to legalize adult use, maybe the 15th, maybe the 17th, depending on who you talk to, but I'll let the legal geeks fight that out. For those outside of New York, this has been a long effort. The first version of the MRTA was filed in 2013. So I'd like to congratulate all the advocates that have been working on legalization efforts here in New York for way longer than that. Too many to name, but it's been a concerted effort and a long time coming. The bill contains a lot of topics that you kind of see listed. I wanted to point out that the MRTA, as you've seen in the stories, has a very strong equity component. A lot of those details are to come in regulations, but it's clear that the New York licensing regime will include a lot of opportunities for social equity applicants. This is in no small part due to the advocates previously mentioned. There were multiple competing versions of adult use bills here in New York, and the advocates really held firm on supporting the MRTA, mainly due to the social equity provisions that were in there. Part of that social equity efforts included the establishment of a New York Cannabis Revenue Fund that'll include, funds for social equity programs and community reinvestment. And we'll talk a little bit more about that later when we get to the taxes. Related to social equity, the bill also includes a multitude of provisions around decriminalization, record sealing, and expungement, which in some cases is automatic. We're looking to do some potential law clinics here in New York with some of the DA offices and the like to assist those individuals in getting their records sealed and their convictions expunged. So please keep an eye out for that. Next, we'll talk about the licensing types that we see in the bill. Just hold on, just making sure the slides are progressing here. So here are the adult use licenses that we see. A few things to note. First of all, the micro business, delivery, and the nursery licenses, according to the MRTA, will be used to promote social inequity applicants. Unclear, what that means necessarily, but obviously, it seems like those license types will be given priority to social equity applicants. There is also on-site consumption, as you can see, which it's been an up-and-coming thing nationally. Not all states allow for on-site consumption, so a lot of people are excited to see that in New York. And then also you can see that there are adult use license types for registered organizations, which is the term for the existing medical operators here in New York. And we'll get to more of that in a bit. In addition, the MRTA also regulates the existing medical and hemp programs. Sorry. And so there are, I'm trying to get the right slide here. I guess maybe lost it. So there are some medical license types that are new, including cannabis research, and then there's also going to be there are also hemp licenses as well covered in the bill. For those that don't know, there are licenses for hemp retailers and processors. Those licenses are already in effect and can be obtained today, and Michelle will talk about more on that later. One of the big questions we get a lot is what are the limitations on vertical integration? So generally speaking, there is no vertical integration on the adult use side. So meaning you have to pick a lane, either cultivation, processing, and distribution, or retail. So those are the two lanes. And I'm not sure what happened to the slide we had here. Sorry about that. The two big exceptions to the prohibition on vertical integration are the micro business licenses and the existing registered organizations, which there are currently 10. Some other noteworthy limitations on the adult use side. Each licensee can only hold one cultivator and one processor license, but each could have multiple locations. It's unclear, what that'll be, how that'll play out in regulations, but we'll see. In addition, cultivators and processors can each have one distribution license. If they do, they can only distribute their own products. And finally, retailers are also capped at 3 licenses, and the same for on-site consumption. There's also a delivery license, and you can only own one delivery license, although it's unclear in the law whether there'll be geographic limitations to that, if any. So that's something to keep an eye out in the regulations. On the medical side, as mentioned, the existing ROs could obtain adult use licenses. The MRTA contemplates a few mechanisms for that. One of them is potentially a one-time fee determined by the regulators, which Jen will speak about, and then also potentially just applying for an adult use license. So that's one of the big exceptions to the vertical integration. In addition to that, for the ROs, they could potentially expand the number of dispensaries they have. Currently, each registered organization has 4 medical dispensaries. They could be expanded up to a total of 8. The one caveat there is that the next 2 have to be in an underserved community as determined by the board. In addition, for an RO that does attain an adult use license, there's one important limitation. They have to sell adult use products through their existing medical dispensaries and only at 3 locations. So the ROs that do obtain adult use licenses, they can expand the number of locations, and they have to have crossover dispensaries that sell both medical and adult use. And then finally, for the ROs that do get the adult use distribution license, similar to the other adult use licensed distributees, they can only distribute their own products. So next, I'll turn it over to Jennifer Cabrera here to talk about the different regulators that we see in the MRTA.
Thank you, Elliot. All right, so as I wait for this slide to load, my name is Jen Cabrera. I've been with the New York office since it was founded in 2019, and also leading up the New Jersey office, which was just recently opened. States have been turning green faster than anyone can keep up with here on the East Coast, so that's exciting. New York's regulators. The MRTA has created a complicated system of regulation. So there is an Office of Cannabis Management and a Cannabis Control Board. The Cannabis Control Board goes above the Office of Cannabis Management. Both of them fall within the jurisdiction of the State Liquor Authority. The State Liquor Authority has no control or involvement in the cannabis program, but that's where they're housed. Effectively, the Cannabis Control Board will be the engine. It'll be the source of policies. It will come up with a decision. It'll create the regulations. Any decisions about whether there will be limits on the number of licenses that'll be granted, that'll come from the Cannabis Control Board. Now, will there be a cap on the number of licenses? We don't know. We won't know until the regulations come out. So the Cannabis Control Board does that. They decide number of licenses, whether there's how they'll be distributed geographically, if there are going to be limits on that, criteria for what they're looking for in applications. Then the Office of Cannabis Management falls under the jurisdiction of the CCB, the board, effectively, and is charged with implementing this program. They are administrators. They're going to actually issue the applications. And if you look, the Office of Cannabis Management website is up and running right now. There are no license applications on it, but there will be at some point. So they will accept the license applications and then turn them over to the board, basically, for their recommendation. The OCM, the Office of Cannabis Management, will have an executive director. That person is going to be nominated by the governor and approved by the legislature, I think by the Senate. And that person is going to be tasked with record keeping, with creating apps and so forth. Then the board is also tasked with appointing a chief equity officer who's going to ensure that the program complies with the state's social and economic equity plan, and also a cannabis advisory board, which will be made up of representatives of a number of state departments as well as other members. And I'm conscious of the time, so moving forward. So the topic that I imagine a lot of you are interested in learning about today is the timeline for regulations. Have I gone too far? Well, it's possible that slide is no longer with us. Timing for regulations. Okay, there is no timing. That is the short answer for it. The MRTA is incredibly light on giving any deadlines, either for the appointment of the board or the OCM. It doesn't give any timing for regulations. It doesn't give any timing for the when license applications will be available. We have had some guidance from the legislature that adult use sales could commence within a year, 12 to 18 months. Some people say it could take longer. Those first adult use sales will be by the registered organizations. As Elliot was describing, those are the entities that are actually, those are the entities that are currently serving the medical market in New York. So the registered organizations who decide to sell to the adult use market, they'll be the first to start selling. But we don't know when new applications will be available for other applicants. There is a limited amount of guidance in the law that sort of give us some clues. For instance, towns need to opt out. If they want to opt out of retail sales, they need to do so by the end of the year. And my colleague Brandon will be talking about that more. But that's some guidance. So end of the year, some things will be happening. Within 6 months, the board needs to issue home grow cultivation regulations for the medical market. However, it's unlikely that regulations for the entire adult use market will be available in 6 months. Really, we're kind of operating on the assumption that we may see something by the end of the year, but it could be longer. Honestly, it's unlikely that license applications would be available before 6 months is up. So that's basically what we know for now. It's a constantly developing situation, but we will have better idea of where it comes very soon. So with that, I will turn it over to my colleague Brandon, who will talk about local licensing.
Thanks, Jen. The local licensing component is fairly interesting in New York. We don't have a ton of details like with anything else, but what we do know is that there are certain licenses that towns can opt out of, or municipalities can opt out of, and certain licenses that they can't. So generally speaking, a town can opt out of retail and social use but they cannot ban or opt out of any of the other licenses. That's the RO, the registered organization, the medical ones, the hemp, the delivery, manufacturing, all of the other licenses. When it comes to towns or municipalities that don't ban social use and retail, the municipalities are permitted to implement time, place, and manner legislation for or zoning for those uses. And they cannot, as the law says, implement time, place, and manner for any of the other license types. So it'll be interesting to see how that plays out. With the retail and the social consumption, the time, place, manner restrictions cannot make the operations of the businesses impracticable. One other interesting aspect is municipalities can't issue cannabis licenses. So in some states like Massachusetts, there'll be like, a local license process. That will not be the case as the law is written right now in New York. They can have zoning permits, but not cannabis licenses. As Jen mentioned, if they're going to opt out, they need to do it by the end of the year, but that can be overturned by a referendum in that municipality. And then, when it comes to applying for these licenses, there's going to be a notice provision, and basically you will submit a notice to the municipality where you are trying to locate a retailer or social consumption license, and then the municipality provides feedback as to whether they support it, and that becomes part of the record for the application. So if the town opts out of the retail or the social use, they don't get a portion of the taxes that are apportioned for the sale of, from marijuana sales. And from what we understand, opting out of retail or social use does not prohibit delivery in that municipality. So we're kind of continuing to monitor it. As Elliot mentioned, we're seeing a lot of towns and municipalities start to consider opting out of the retail and the social use, and we're gonna keep looking at this closely. So I guess obviously equity is a big part of this law, and there's a lot of language on the equity considerations, and the state has been very thoughtful in terms of how they want to ensure participation. So the stated goal is to award 50% of the adult use licenses to equity applicants and ensure inclusion. There is going to be the appointment of a chief equity officer who's basically going to be in charge of overseeing and implementing the social and economic equity plan. This is meant to encourage participation from people that have been disproportionately impacted, minority-owned businesses, women-owned businesses, distressed farmers, and service-disabled veterans. So the CCB has the authority to change the number of licenses and license renewals to ensure that the program is meeting its anticipated equity goals. So part of the renewal process is going to be to make sure you submit information about your diverse ownership and the steps that you are taking as an organization to ensure that you're furthering the equity goals of the program. There is also going to be an incubator program that's established as part of the social and economic equity plan, which is basically going to provide education and counseling for the people that qualify for these economic and social equity benefits to help them through the application process. The fees for the licenses for these groups are going to be reduced or waived, and the law also enables the ability for the state to provide low interest or zero interest loans to these businesses to help them get up and running. And that really kind of just scratches the surface. It'll be interesting to see, how all of these considerations are implemented as things move forward. And, obviously we're going to be monitoring this very closely to see how it all plays out. I think there's, just kind of continuing on, this is really the strongest bill that we've seen amongst any of the states, taking equity into consideration. And I think that it's really great to see all of this in the law. And then, the challenge will be making sure it's properly implemented to make sure that folks actually get the benefit of what is written. Briefly on the criminal law. So obviously, there's a lot of things that have changed to say that, probable cause for odor of cannabis or odor of burnt cannabis or existence of cash next to cannabis don't result in probable cause for a search anymore. And then you have possession limits, which are personal possession of 3 ounces of flour, and I think it's 24 grams of concentrate. But there's more criminal law changes going beyond just personal possession to what you can possess in your home, what you can grow, and going up from a misdemeanor to a felony in certain cases if you have well beyond what is permitted. So that is essentially a high-level review of the equity components here, and I'll turn it over for ownership restrictions.
Thanks. All right, so I can talk about ownership restrictions here a little bit quickly because we already covered it with respect to different license types, but I think it might be valuable to talk about it again because this is a key component of the bill. One thing I'd note is that the language included in the bill is pretty broad in terms of it picks up sort of direct or indirect interests. You don't always see that language in bills, in which case it becomes a little bit unclear whether it's possible to structure a transaction in a way that you wouldn't be off sides of a vertical integration requirement if you had some sort of IP licensing arrangement or maybe a loan. Based on this bill, and obviously subject to the final rules, I think that they intended this to be quite tight, and I don't think that there's going to be room, and I certainly wouldn't suggest trying to structure around these requirements. So, at a very high level, it's a looser version of a 3-tier alcohol model, and I say looser version because if you're a grower or a processor, you can obtain a distributor license, but only to distribute your own products. Otherwise, you really have to choose a lane between grower processor and retail store. And you're also limited in terms of how many licenses you can own within each category, though some of the license types imply that you'll be able to get multiple locations with one license. So I saw questions actually just come in. I'm going to stop looking at these questions so I can focus. But in terms of that residency requirements and out of state, there actually is some residency requirement in the bill in terms of the actual license holding entity. And we'll have to look at the final regulations, but there are language around, it's a very light residency requirement, and I think you're going to be able to get around it just by having a New York entity hold the license. But I would caveat that you're going to have to wait till the final rules for that. Again, there's certain business crimes that may prevent ownership, but they specifically carve out certain drug dealing crimes, again, because that would violate the goal of the bill, which is to rectify the harms of the drug war. And then I mentioned this light residency requirement, which I don't anticipate to be an issue. for transactions, but it's worth noting that there is something in there. Some states, like a Massachusetts, require you to use an entity formed in that state to hold a license, and in other states, the state's sort of agnostic as to where you form it. I think New York's going to be in the sort of the Massachusetts model there. All right, taxation. I'm going to go through tax quickly here, but at a very high level, you have this THC content-based tax, which kicks in when the distributor sells to the retailer. So it's not at the point of sale. This is a B2B sale. And there's a different tax rate, whether it be flower, concentrates, or edibles, which is sort of an unusual tax concept here. And then there is an additional tax, sales tax that applies at the B2C level when you sell to the customer. The 9% sales tax goes to the overall fund, and then the 4% sales tax is split in sort of an interesting manner, which we're not going to get into the details here, but just bear in mind that's sort of reserved for the localities. And if you opt out, you're not going to get access to that money. We also don't really have time here to get into the actual mechanics of how this gets paid. But some of these taxes are monthly, some of which are paid quarterly. It all goes to the New York State Cannabis Revenue Fund. And then sort of after deducting for a wide range of things, which are outlined in the bill and all are essentially administrative in nature, 40% of it goes to Community Gains Reinvestment Fund, 40% to equity, and 20% to drug treatment and public education programs. So I think Elliot you see different numbers thrown around in terms of estimated how much tax people anticipate to raise here. We expect it to be a fairly significant amount of money, given the size of the economy of New York State. So I think this will be a meaningful amount of money. But again, I think you're gonna have to wait for the rules to get the details on taxation. And then on the medical side, there is an excise tax on the gross receipts of the sale of medical cannabis. And it's interesting that Bill knows it can't be a separate charge or line item for the patient, and this gets paid monthly. All right, transaction considerations. And this was one where I think it's especially worth noting that it's hard here to talk about this stuff in the absence of the rules, because a lot of this stuff gets, the transactions are complex enough that it has to get defined in rule to actually look at it. So one thing I thought was interesting is that it says that a license, permit, or registration cannot be pledged or deposited as collateral security for any loan or any other condition. I say not clear how this will work because it doesn't say that you can't put a lien on a license, just that the license can't be pledged or deposited as collateral security. Now, I think that they'll spell this out in rules to make it clear that you can't put a lien on the license. But that's an interesting point because you see in different states, most states don't clarify whether you can use a license as collateral for a loan. And from what I'm seeing on the debt transaction side, it's quite common to include an all assets lien for these deals. So curious to see how that one plays out. And the other big one, I think here from a debt financing perspective is the language basically implies, at least my read, is that any loan would require an update to the Office of Cannabis Management. Interesting question, because in a lot of states, it's not clear whether borrowing money is something that requires regulatory approval or regulatory disclosure. And in some states, I would say certainly, as a matter of practice, nobody is telling the regulator about their loans. And we're not seeing any enforcement there, so it actually puts you at a profound disadvantage if you disclose it to the regulator. So I'm curious to see what the rules say in terms of disclosure of loan documents. And then on the M&A side, big change here is you can't transfer licenses for the first 2 years of operations. And then social and equity can't be transferred for 3 years. And I didn't put it here, but I believe the social and equity can then only be transferred to another social and economic equity buyer. So that'll impede the value of those licenses. You'll also see the transfers require prior written approval at the state level. I don't anticipate needing approval at the local level. As Brandon talked about, for retail and for on-site consumption, the localities can regulate time, place, and manner. So does that mean that they could have an approval condition to transfer a local dispensary license? I think it's possible. I just don't know if we can say for certain at this point, especially because we haven't seen any of the local regulations yet. And the other thing is, the definition of transfer is fairly robust, and I imagine it'll get fleshed out even further at the rulemaking session, because from my perspective, does a SPAC transaction trigger prior written approval? I think we'll have to see the final rules to determine whether that's the case. And then in terms of these prohibitions on transfers in the initial few years of licensing, you have to think about, is this something that you could work around with an option? They don't really discuss convertible equity or warrants in the law, but it could be discussed in the rule. So we'll have to see what happens there. But I think you are going to see some unique New York contours to cannabis transactions. And with that said, I'm going to turn it over to Michelle.
Well, as exciting as that was, Charlie, I hate to follow up SPAC. And for those of you who don't know what that is, feel free to reach out to Charlie. He has a lot of very interesting things to say on the topic. So just moving to something a little bit more plain Jane, hemp and cannabinoids. As you saw, the adult use bill, the MARTA, does include cannabinoid hemp regulations as part of this new law. This doesn't supersede or change the existing hemp law that's already on the book. What it does is add some new criteria and some expanded information. But in essence, the Department of Health currently has authority over cannabinoid hemp retailers, distributors, and processor. That authority is staying with DOH for right now. Eventually, that will shift to the new Office of Cannabis Management. In the meantime, all applications are still posted. They're still accepting applications, and they're still processing them. Right now, that processing timeline is kind of an instantaneous. Within 15 minutes, you should get an auto-approved retailer, distributor, or processor license. That's a temporary license until the regulations are final. And the regulations were on track to be finalized in the next couple of months. But of course, this adult use bill kind of threw a wrench in that timeline. So what we're looking at now for cannabinoid hemp regulations and getting those final licenses and approval is kind of up in the air. We're thinking it might be a few more months, pushing back that timeline until any of these registrations are official and finalized. So just reiterating what's in this MARTA that was already existing in law, there's two license type, hemp processor, hemp retailer, and within retail there's also a distribution license. One change, one expansion that MARTA did do is specifically saying nothing in law will prevent the sale of cannabinoid hemp flower. So the draft Department of Health regulations related to hemp had prohibited smokable hemp flower. Now this new law says there's nothing to prevent that. It must be sold to people 21 plus, and any hemp flower labeled or advertised for smoking can only be sold in the adult use cannabis retail dispensaries. And then regulations, like I said, will be forthcoming in the next several months, potentially with the adult use, or can be passed through with a separate authorization there. And then jumping back to adult use, advertising, marketing, and packaging, there's really nothing earth-shattering in MARTA that isn't under any other state's program. Ultimately, the rules and regulations will establish methods and procedures for determining serving size, active cannabis concentration, methods of separating and serving sizes, nutritional supplement information. There will be a list of approved product types and forms. There's also supposed to be establishment of application and review process to review the suitability of new product types. And ultimately, as stated here, no public transit advertising, no false misleading, nothing attractive to children, no medical claims, and no billboard requirements, but nothing too unique right now in the law that would be any different than what other states are doing. But ultimately, like every other topic, it's kind of a wait and see. The details will be in the regulations. turning it back over, what can be done in advance of licensing?
All right. So this, guys, as I mentioned your name, could drop back in here. It's a tough question, right? So let's go through some options here. One thing, I don't think we put it here. This is more licensing focused, but definitely pay attention to the website and pay attention to the rulemaking process. We don't have hard dates on rulemaking process yet, but when the rules come out, there will probably, usually there's an opportunity to sort of comment on the rules. It's certainly something we can help with, but don't assume, the regulators do take comments on these regs, particularly where I think if you're able to point out something that just doesn't work, because sometimes, it's not an easy job to write these regulations. There's a lot to be done there. And it can be helpful to the regulators to point out certain things that just don't make sense in the context of the law. So do that. I don't believe the website has a sign up to get updates yet, but when that happens, you definitely want to do that. So that's just on the website. Think about what sector you want to pursue, right? So as we talked about in this presentation, you're not going to be able to be vertically integrated unless you're an existing medical operator. So, do you want to be consumption, retail? Do you want to be cultivator? You got to make that decision up front. And obviously everything else is going to flow from there. Building your team. If you're competing for one of these licenses, and noting the very strong emphasis on social and economic equity in the bill, you want to make sure you take that into account when you're building your team. Building the team is one of the major elements of winning one of these licenses if it's competitive. Now, bear in mind, we don't know exactly how many licenses they're going to issue. It could be a huge number, it could be a small number. It's up to the CCB. But I think it's worthwhile preparing for what we think is going to be a competitive licensing process. Develop experience out of state. I mean, if you're not already a cannabis operator, strongly suggest getting involved in a state where there are actual operations right now in advance of applying in New York. It doesn't have to be much, but I don't think you want to be applying and telling the regulators you've never been involved in one of these businesses when there's so many people out there that have been operating for, in some cases up to a decade. Think about financing capacity, pro formas, what's it going to cost to build out? Are you going to raise money? We don't have hard information here about what sort of financial capacity they're going to require, but it's always helpful to be able to show financial capacity to build out facilities. So think about that. Evaluate real estate. I mean, this is another major prong of winning a license, is determining where you're going to be located. Now, as we talked about in these slides, we don't really have all the information we need to be able to tell you what location will or won't work. You could definitely say at this point, there's certain locations that won't work due to proximity to, say, a church or a school, but there are going to be additional regulations at the local level, particularly for retail and social consumption. So that's something to think about. Identify key themes. That's in terms of, part of license application is it's a storytelling process. What's the story behind your team? Why should you get a license? Think about that. Social and economic equity, obviously hugely important to the regulators in this bill. So make sure that you're thinking about that. Civic engagement. This may be important both at the state level and the local level. You already see a number of towns saying they're going to opt out. So you want to think about civic involvement and getting involved in the process. You're not an unknown player to the regulators. And then, of course, lastly, we got to push the merch here. Give us a call. We can definitely help you. We got a very deep bench. We've worked on a ton of these merit licensing applications. We're the only law firm out there that won a license in the initial New York licensing round. So we can help you. Obviously, we don't know exactly how many people we'll be able to help in the final process, but we'll do everything we can to help you right now. And then before I give everyone a chance to hop in, I just want to point out for the group here, questions in a second, but just mention our book on cannabis law, which I suggest you pick up whenever you like to buy books, buy it on Amazon. You can buy it on Bookshop if you want to support small independent bookstores. Sort of covers cannabis law. I think it provides a good background. If you're new to the space, it might be helpful. So I want to open it up to my colleagues again to see if they want to talk about anything related to pre-licensing tips and their kind of advice to the group before we check on questions.
Hey, Charlie. I guess, kind of related to some of the questions that we're seeing in the chat and about pre-licensing, people are talking about looking at locations. I think I mentioned in the slides here, we do have some insight as to some of the property requirements, but unfortunately, I think a lot of that will be determined in regulations and also the local zoning requirements. Right now, what the MRTA contemplates is you have to be 500 feet from school grounds as defined in the education law. I know there's a question in there, and we do think that private daycare centers may be captured by that definition. We'll see more clarity on that when the regulations come out. In addition to being 500 feet from a school, you need to be 200 feet from a place of worship. Again, that definition is unclear, but we do understand that the liquor authority does have a map where you can kind of look these things up. We've looked at it, compared it to other maps. It doesn't necessarily overlap with respect to the schools and the places of worship, so you may have to check multiple maps, including looking at Google, just to see if you can see a school or a place of worship on the map when you're looking at that. So just keep that in mind while people are looking for locations. Another kind of common theme we're seeing in the questions is the local opt-out. And yes, I'm from Long Island, and I'm seeing all the stories about a lot of Long Island mayors already kind of saying they'll opt out. I understand there's a movement among the entirety of Long Island to potentially opt out together. Obviously this is not really desirable, and we think it's a little short-sighted. And again, as a reminder, though, it looks like the local opt-out only applies to retail and on-site licenses. So even if they opt out of that, delivery, production, cultivation, looks like it could still happen within those communities. So bottom line is, opting out isn't going to keep cannabis out of these communities. And as everyone already knows, New York is one of the largest cannabis markets in the world already, even without adult use legalization. So cannabis is in all these communities in the unregulated market, and we firmly believe that opting out is going to keep those legacy markets in place, but opting in obviously encourages regulation. We think it makes a safer marketplace for everybody, and also brings in tax revenue for the local coffers.
Yeah, and then in terms of people have been asking questions about, is there information on what localities have opted out? Jen, correct me if I'm wrong, but I know we're working on a list tracking this.
Yes.
Obviously there's 1,600 municipalities in New York State, so it's a little bit difficult to have a complete list. So, we may have like a bias towards more populated areas where it's easier to find.
The goal is a complete list. So, and it is very long indeed.
Yeah.
Yes, we are monitoring towns that are talking about opting out, and also a number of towns are going to be passing zoning ordinances in the coming months. They have only 9 months. Well, they have 9 months to opt out, but during that time, a lot of towns are going to pass ordinances. So we're tracking that. So that is something that we are sharing with clients.
Yeah, and just like everything else, right? So we don't know. There's no final answers right now. We'll know more by the end of the year.
It's also challenging. A lot of the clients that are coming to us with addresses of where they're looking to locate, it's incredibly difficult because we can tell whether or not a location is suitable under the guidance in the MRTA, but we don't have state regulations and we don't have local regulations. And without them, there's just no way to know for certain if a property is zoned properly. We'll know as time goes on, but it's a challenging thing at this point. So I caution everyone against entering into real estate contracts too early.
Yeah, thanks, Jen. And just so I've seen a number of these questions, but we're going to be sending around the PowerPoints to everyone who registered for this. So, no need to ask again. We'll make sure you get that. So let's see what other question we have.
Yeah, so I was sorry, I see a lot of questions about the tax rates and whatnot. So just a few points there. As Charlie mentioned, the potency tax is pretty unique to New York. It's something we haven't really seen elsewhere. I think the closest we see is Illinois, where if your product's above a certain THC threshold, there's an additional tax, but it's a flat tax. Where here in New York, it's graduated based on the potency. I think a lot of people that are already in the space realize that there is a national movement, to kind of regulate potency in products, and so, this is one of New York's attempts to do that. The MRTA does also implicate that the board and the OCM will adopt regulations around potency, so that's something to keep in mind. People have been asking about kind of the effective tax rate, and just to remind people, we're talking about cents here, so it's for each milligram of THC in a flower, it's $0.005. We're talking about a half a cent, not 5 cents. So just in case people are modeling that out, people smarter than me have looked into this, crunched the numbers, and essentially the effective tax rate comes out somewhere in the mid 20s, maybe the upper 20s, but that puts New York kind of on the upper end of the effective tax rates where adult use is legalized. So unfortunately, we do think that may kind of incentivize the legacy unregulated market to stick around, but at the same time, this is the way New York wants to regulate it with respect to potency. So I just wanted to note that for everybody.
Yeah, and on terms of the legacy market, I mean, this ties into the question I see from Rochelle here. Can someone discuss more about the criminal consequences of the new law? So, as part of the new law, they made a number of amendments to the penal code in New York, significantly reducing penalties for possession. So, I think another thing to keep in mind here is, I think it's going to be important to track what percentage of the legacy market remains intact post licensure, as there will be limited criminal penalties against the legacy market participants. So that's an important thing to note here, is that the penal law has been changed in a very progressive manner.
And not to rain on everyone's parade, but I know a lot of the stories and summaries have said that possessing up to 3 ounces of cannabis is now legal, and 5 pounds in your home. The MRTA does include this concept of illicit cannabis, and essentially, if your cannabis hasn't been taxed through as the MRTA requires, it's technically illicit cannabis, and it's illegal to hold illicit cannabis. Now, obviously the enforcement mechanism there is TBD. I don't really know how they're going to look at your piled cannabis once the tax rate comes into effect, and kind of see if it was taxed or not. So just wanted to throw that out there.
Yeah, and to look at some of these other questions. So Josh, question is New York going to apply 280E to state income tax calculations? I did not see a mention of that in the bill. It could be mentioned in the rules. I could have missed it too. I wasn't looking for it specifically, but I talked to some accountants the other day that said that they didn't see it either. So I think it's an open question at this point.
Sorry to keep jumping back in here. Just a few other points too, just for because of some of the common questions we get. Just again to reiterate on timing, I see a lot of people asking about that for folks that came late. Unfortunately, the MRTA doesn't mandate any really specific timelines for when the regulations and the licensing has to come out. As Jen mentioned earlier, we've seen some statements from some of the sponsors of the bill hoping to have adult use sales within a year, 18 months. That presumably seems to be a registered organization flipping the switch and selling adult use products. We don't think regulations, licensing, and facility build-outs would happen in that time frame. So that's something to keep in mind. Some other things that we saw, the medical law sunsets 6 months after the entire board is appointed. So that seems to suggest that they believe it only takes 6 months to really get the regulations drafted, review and comment on, and finalized. So as Jen pointed out, we're hoping to see regulations, something maybe in draft form before the year end, and hopefully a licensing around, some point early next year. A lot of questions I've also had too on the medical side, and what's going to happen to that. So in addition to the existing ROs being able to potentially enter the adult use side, there is a contemplation that there will be more registrations given out for medical use operators. So that's something to keep in mind for the folks looking to enter the business. Unfortunately, the MRTA seems to suggest that those new registered organizations would not be exempt from the vertical prohibition. So any new registered organizations wouldn't be able to get an adult use license, would have to be on the medical only side. Now, I know people that are already operating in New York understand this. New York has a pretty restricted medical program to date. The MRTA does expand that a bit, including allowing for smokable flower, and also allowing for the physician to really prescribe medical cannabis to the patient if the physician feels it's needed. So we no longer have the kind of qualified condition plus the qualifying symptoms that was required to get a card here in New York. Another thing to keep in mind is that New York does, I've heard this from the regulators and from people in the government, they do want to make the medical program here remain meaningful, meaning that we don't want the adult use market to subsume the medical market as we've seen in some other states. And so what we're hoping to see here in New York is there'll be price controls on medical products. It's in the MRTA. The OCM has to approve any pricing of medical products. In addition, there have been some movement here in New York to try to get workers' comp, Medicare, and all that stuff to cover medical cannabis products. We've seen some favorable case law in other states such as New Jersey. So we're hoping to see that come to play here in New York and really kind of make the medical side of the market here meaningful for those patients that actually need this for the medical purposes.
Question: can municipalities using zoning requirements as an effective way to block cultivation and processing facilities? I don't think it's 100%. My view is it's not 100% clear based on the bill. I think the intent of the bill is to prevent municipalities from doing that. But I think you're still allowed to have reasonable zoning restrictions. Jen, Brandon, thoughts on that?
I agree with you, Charlie, but the bill does say, it doesn't explicitly say, it just doesn't allow towns to impose time, place, or manner restrictions on cultivation. And the comments that we're hearing from the regulators in New York is that they can't do that. So will towns try to do it? I think there's a decent chance they will try, but I think we just need to see in the regulations what zoning is appropriate for cultivation. It may mean that you can open a cultivation facility or a manufacturing facility in any place that's zoned agricultural or industrial. We just need to see the regs.
Just to add on to that too, Brandon mentioned that at least for retail operations, there'll be this notification requirement where you have to notify the municipality that you're applying for a retail license, and the municipality can give you a thumbs up or a thumbs down, and that'll be taken into consideration whether the board approves your license. We're not clear kind of how that process will play out in reality. The notification is supposed to be on a uniform form, we think, to try to prevent, some kind of gamemanship that we've seen in localities in other states. But the fact that the municipality can give you a thumbs up or a thumbs down, and that'll be taken into considered licensing, suggests that there will be some interplay between the licensee and the town. So for the folks that are looking to obviously, site businesses and think about, where they want to place their operations, you got to get out there, talk to your local politicians. You got to get them, on board for adult use, making sure they're not opting out. And then ultimately, too, making sure that whatever local requirements they do put in place aren't overly burdensome to the point where it makes it impossible to set up your business in a profitable manner.
Right. And just one thing to add, if a municipality opts out, it can then reverse through a referendum down the road. So, if they opt out and sort of, act too quickly on, what's something that's going to provide income, and as what Elliot said, you can't prevent these other licenses. If you see the sky isn't falling, or there's a push from the residents of the municipality, then a ban could be reversed. I don't think we see it too often in other municipalities, but the possibility does exist under the law. So something for folks to think about.
And Brandon, that's similar to what happened in Massachusetts in a way. Cape Cod initially, the whole Cape was against cannabis businesses, and that did change.
Yeah. I mean, I think we've seen in Massachusetts and other states is that, when your neighboring municipality is bringing in significant revenue from these businesses that is, that can be used for, the local schools or roads or whatever it may be, and that there aren't really any detrimental impacts that are being created by these businesses. I think municipalities see the benefit of having them and then allow for them. So hopefully that's the case. Everybody's a little I guess nervous about these uses at first, or some people are at least, and then as the programs evolve and mature, I think people those concerns are alleviated a bit.
Well, also what Elliot said, that you're just keeping the regulated market out. You're not keeping cannabis out. Cannabis is in your town already. Why don't you just keep it safe?
Right, you can't stop delivery either.
And delivery, exactly.
or cultivation.
Or hemp, just to pipe up there.
Yeah, so let's see, are there any links you can point us to outlining qualifications for social and equity applicants? So, if you look at the bill on the adult use side, it is, what is it, section 87?
I'm sorry, Charlie, you printed that? You printed all 128 pages.
Yeah.
I'm very impressed.
Section 87 gets into the definition of social equity. It's individuals from communities disproportionately impacted by the enforcement of cannabis prohibitions. That one is going to be very important to see what the rules say, right? Are they going to give specific zip codes? How long have you had to live in the zip code, et cetera? Minority-owned businesses, which is, they define further, woman-owned businesses, minority and women-owned businesses, distressed farmers, and service-disabled veterans. But the short answer is wait for the rules, because certain things like, I think you could have a pretty clear idea of what will qualify as a woman-owned business right now. But the disproportionate impact one's hard to give advice on at this point, because there's just very little in there. All right, I think we got time for one last question. Are municipalities, this is a good one because we've been talking about this internally. Are municipalities going to be able to cap the number of retail stores within their borders? Could they achieve that result by placing large setback requirements between stores? So the bill says they can regulate time, place, and manner, and they can also opt out. To me, it seems like that would allow you to limit the number of retail stores, but I don't think it's perfectly clear, and some of my colleagues may disagree right now.
Well, they can't issue local licenses, and it's not clear that they could impose a cap on the number. So if they're not having local licenses, then they're giving out special permits, right? And are they going to say we're only going to give out 5 special permits? I'm not sure. That may be considered too close to licensing. I do think, though, that the setback requirements or buffers between locations, if they are allowed to do that, that would be an effective way to limit.
The local section of the MRTA does include this, language that any local time, place, and manner restrictions can't be, unreasonably burdensome as determined by the board. So it looks like there might be some type of process to appeal like a local requirement if it's in fact pretty heavy-handed. But again, we'll have to see kind of the details around that in the regulations. Right,
and I think it's also going to point out, there's 1,600, we said 1,600 municipalities in New York State. I don't know if one municipality decides to sort of go beyond its authority under this bill, is the CCB going to reach out directly and stop them, or is it going to take, a licensee causing a fuss for something to happen? I think that not all retail locations are the same, and I imagine that there's going to be a lot more hubbub about the valuable foot traffic locations, right?
Yes. I think also a lot of towns, it's going to be really difficult to find a spot that's far enough away from a school or a place of worship. Like most of the 5 boroughs, for instance, I think
the other challenge, the other thing someone pointed out the other day is, a lot of, especially in the 5 boroughs, right? If you're talking about places that have mortgages, the mortgages may prohibit cannabis activity on the premises. So it may be difficult to locate in kind of like a large commercial multi-tenant property in Manhattan, for example, for that reason.
Unless you want to buy the building.
Right.
Well, there are people that'll do that.
That's a good question. Does the distance requirement, I guess if you're on the top floor of a building, can you claim that you can count the distance to something on the plus? I don't think so, right?
No,
I think there's actually a street level entry requirement.
Street level, yeah. Anyway, that's enough speculation for one day. Well, thanks everyone for joining us. And like I said, we're going to send this PowerPoint around to everyone who registered, and reach out to us if you have questions, and we'll continue monitoring this thing as it moves forward.
And as we get more answers, as the regulations come out, we'll hope to see you all again for another update. Since a lot of our questions and answers are hold tight, we'll know more in the future.
And maybe we'll have one on Connecticut.
Maybe.
That state, yeah. Saw some positive signs there.
Cool.
All right.
All right.
Take
Thanks,
care,
everyone.
Thanks, everybody.
Yeah.